Imagine getting sued for making customers click a button twice instead of once. In 1997, Jeff Bezos filed a patent application that would spark one of the biggest controversies in tech history and help Amazon dominate e-commerce for 2 decades. This isn't just about selling books online. This is about this one patent, a legal document so controversial that it made the founder of the Free Software Foundation call for a boycott, forced Apple to write a check for $1 million, and eventually helped reshape how America thinks about software patents. And the wild part is, nobody can even agree on whether this was genius or theft. I'm going to break down exactly how this patent works, why it caused such massive controversy, and what actually happened when Amazon weaponized it against competitors. Because whether you think this was brilliant business strategy or exploitation of a broken system, the story reveals something important about how competition really works in America. Let's go back to the mid-1990s. Amazon launched in 1995 as an online bookstore. Back then, buying anything online was painfully slow. You're using dial-up internet. Each page takes 30 seconds to load. You find a book you want, add it to your cart, then you have to go through this multi-step checkout process. Enter your name. Wait for the page to load. Enter your shipping address. Wait again. Enter your billing address. Another wait. Type in your credit card number. Wait some more. Then finally, confirm your order. The whole process could take 5 minutes or longer. Bezos is watching the data and he sees a huge problem. People are abandoning their shopping carts right before they finish buying. They'd go through 3 or 4 steps, then just close their browser and leave. Amazon is losing sales, not because customers don't want the products, but because the checkout process is too annoying. Every extra click, every extra page load, every extra form field is costing real money. Most companies just accepted this as normal. That's how online shopping works, right? But Bezos saw it differently. He's thinking, what if we could cut out all those extra steps? What if buying something could be as simple as clicking one button? So he tells his engineers to build something new. The idea is simple. Amazon already has your information stored from previous purchases. Your name, address, credit card, everything. Why make you enter it again? Why make you confirm anything? Just put a button on the product page that says, Buy now with one click, and when you press it, the purchase happens instantly. No confirmation page. No review your order screen. Just click and done. The technology itself was straightforward for experienced programmers. Amazon servers would store all your payment and shipping details. When you clicked the button, their system would automatically pull that stored information, process the payment, and create a shipping label, all in less than a second. From the customer's perspective, you click once and the item is on its way to your house. Amazon launched One Click in September 1997. Customers loved it. It was fast, easy, convenient. Exactly what online shopping needed. But here's where the story gets interesting. Bezos didn't just build this feature for Amazon to use. On September 12, 1997, the same month they launched it, Amazon filed a patent application with the United States Patent Office. The official title was Method and System for Placing a Purchase Order via a Communications Network. Everyone just called it the One-Click Patent. 2 years later, on September 28, 1999, the patent was officially granted. Patent number US 5960411A. This gave Amazon exclusive legal rights to single-action purchasing on the internet for the next 20 years. That means any other company that wanted to let customers buy something with one click would either have to license the technology from Amazon, design around the patent, or get sued. Amazon didn't just build a better checkout system. They built a better checkout system and then used the legal system to prevent anyone else from doing the same thing. The business impact was significant. Amazon's conversion rates went up. One study found that one click increased completed purchases by about 28%, for customers who used it compared to the standard checkout process. When you're doing hundreds of millions of dollars in sales, a 28% boost on a portion of your transactions is massive money. But the real advantage wasn't just about Amazon's own sales numbers. It was about keeping that advantage away from competitors. Barnes & Noble was Amazon's biggest rival in online book sales. In 1998, they launched their own website to compete. And in 1999, they introduced a feature called Express Lane that worked almost exactly like Amazon's one-click. You could store your payment information and buy a book with a single click. It was basically the same thing. Amazon sued them immediately. The lawsuit was filed in October 1999, just weeks after Amazon's patent was granted. Amazon asked the court for a preliminary injunction, which is a legal order that would force Barnes & Noble to shut down Express Lane while the lawsuit played out. In December 1999, the judge agreed and issued the injunction. Barnes & Noble had to disable Express Lane right before Christmas, the biggest shopping season of the year. Barnes & Noble appealed the injunction, and in February 2001, an appeals court actually vacated it, meaning they overturned it. But by that point, the damage was done. Barnes & Noble had already been forced to remove the feature for over a year during a critical growth period for online shopping. And even though the injunction was overturned, the patent itself was still valid. The lawsuit eventually settled, and Barnes & Noble changed their system to require at least 2 clicks instead of 1. Amazon had won. Think about what this meant for competition. Amazon could offer the fastest, easiest checkout on the internet. Their competitors had to make customers take extra steps. In e-commerce, speed matters. Convenience matters. Cart abandonment rates are around 70% across the industry. Anything that reduces friction increases sales. Amazon had a legal monopoly on the lowest friction checkout process, and they defended it aggressively in court. But wait, it gets even more interesting. In 2000, Apple was preparing to launch the iTunes Store. Steve Jobs understood the same thing Bezos did. If you want people to buy digital music, you have to make it incredibly easy. Jobs wanted one-click purchasing for iTunes. But Amazon owned the patent. So Apple had to negotiate a licensing deal with Amazon. The companies agreed to terms where Apple paid Amazon $1 million for the right to use one-click technology in the iTunes Store. $1 million might not sound like much for Apple, but think about what that represents. Apple, one of the most innovative companies in the world, had to ask Amazon for permission to use a basic feature in their own product, and they had to pay for it. That's not just money. That's control. Amazon was collecting a fee from iTunes transactions without having to do anything. The patent did the work. Now let's talk about why this patent was so controversial, because the backlash was intense. The tech industry hated it. Programmers, software engineers, other e-commerce companies, they all said the same thing. This is not a real invention. This is an obvious idea. Storing customer information and processing orders automatically is not new. All Amazon did was remove a confirmation step. That's not innovative enough to deserve a 20-year monopoly. Richard Stallman, the founder of the Free Software Foundation and a major figure in the open-source software movement, called for a boycott of Amazon. He urged people to avoid buying from Amazon until the patent expired. The boycott lasted for years. Tim O'Reilly, a respected tech publisher, organized protests and wrote open letters criticizing the patent. Thousands of people in the tech community signed petitions demanding that Amazon give up the patent or that the patent office revoke it. The criticism got so intense that even Jeff Bezos himself responded. In March 2000, he published an open letter on Amazon's website. He basically said, "Look, I hear you. The patent system needs reform." He suggested that software and business method patents should only last 3 to 5 years instead of 20. He admitted the current system was creating problems. But notice what he didn't do. He didn't give up the patent. He didn't stop enforcing it. He acknowledged the criticism, suggested theoretical reforms, and then kept using the patent to maintain Amazon's competitive advantage. Here's the thing about that letter. It was smart public relations. It made Bezos look reasonable and open to reform. But it didn't change anything. Amazon still had the patent. The courts were still enforcing it. Competitors still couldn't use one-click purchasing. The boycott didn't hurt Amazon's business in any meaningful way. The company kept growing. The letter was basically Bezos saying the system is broken, but I'm going to keep winning under the broken system until someone fixes it. And nobody fixed it in time to matter. The deeper issue here was about what should be patentable. For most of American history, you couldn't patent software or business methods. The Patent Office would reject those applications. Patents were for physical inventions, machines, chemical processes, manufactured products, things you could build and touch. The reasoning was that math, algorithms, and ways of doing business were too abstract to patent. If you could patent business methods, every company would patent every little process they used, and competition would become impossible. But that started changing in the 1990s. There was a court case in 1998 called State Street Bank versus Signature Financial Group. That case established that business methods could be patented if they produced a useful, concrete, and tangible result. The ruling opened the door for a flood of business method and software patents. The one-click patent was one of the first major patents approved under this new interpretation. This created a massive shift in how tech companies operated. Before, if you had a good idea for software, you'd just build it and try to execute better than your competitors. After State Street Bank, companies started racing to patent everything. Every feature, every process, every minor variation on existing ideas. It became an arms race. Companies built huge patent portfolios, not because they planned to use all those patents, but because they needed defensive ammunition. If another company sued you for patent infringement, you could countersue using your own patents. This is called mutually assured destruction in patent law. Big companies could play this game because they had money for lawyers and massive patent portfolios. Small startups got crushed. If you were building a new app or website and some corporation decided you were violating one of their hundreds of patents, you couldn't afford to fight them in court. Patent litigation costs millions of dollars. So small companies either paid licensing fees, changed their products to work around the patents, or just shut down. The one-click patent became a symbol of everything critics thought was wrong with the patent system. Let me break down how the patent actually worked technically, because this matters for understanding the controversy. The patent describes a method and system for placing orders. Here's the basic process as written in the patent document. First, the server system receives a request to display information about an item. That's when you load a product page on Amazon's website. Second, the server sends the information to your computer, along with an indicator for ordering the item with a single action. That's the one-click button appearing on your screen. Third, the customer performs a single action, like clicking that button. Fourth, and this is the key part, the server system receives the indication of the single action and generates an order for the item using previously stored customer information without requiring any additional customer input. The patent specifically defines single action as completing the purchase, with just one interaction from the customer. No confirmation clicks, no review order page. One action and the order is placed. That specific definition is what made the patent enforceable. If a competitor required even one additional click to confirm, they could argue they weren't violating the patent because they weren't using single-action purchasing. That's why Barnes & Noble eventually switched to a two-click system. One click to say buy, another click to confirm. It's less convenient, but it avoided Amazon's patent. Critics argued that this patent was claiming ownership of an obvious improvement. Any programmer could have implemented this. Multiple companies were probably already working on similar systems. Amazon just happened to file the patent application first. The patent office approved it, so now everyone else was locked out for 20 years. That's not rewarding innovation. That's just rewarding whoever filed paperwork first. But supporters of the patent, and there were some, argued that Amazon did invent something specific. They created a particular technical implementation of single-action purchasing that involved specific server architecture and data handling. The patent wasn't claiming ownership of the abstract idea of making checkout easier. It was claiming ownership of a specific method of implementing that idea. If competitors wanted to implement single-action purchasing differently, with different technical architecture, maybe they could do that without violating the patent. The problem is, in practice, there aren't that many ways to implement one-click purchasing. You need to store customer data. You need to process it automatically when they click. The variations are minor. So even though the patent was technically for a specific implementation, it effectively blocked the entire concept of single-click purchasing for 20 years. The financial impact on Amazon is hard to calculate precisely. The company's revenue went from about $1.6 billion in 1999 to over $135 billion in 2016. Obviously, the one-click patent wasn't responsible for all that growth. Amazon expanded into marketplace selling, cloud computing with AWS, video streaming, hardware like Kindle and Echo, grocery delivery, and dozens of other business lines. The one-click patent was just one small piece. Some analysts have tried to estimate what the patent was worth. Estimates range from around $1 billion to maybe $2.4 billion in total value over the patent's lifetime. That includes increased sales from higher conversion rates, licensing fees from Apple and potentially other companies, and the competitive advantage of offering faster checkout than rivals. But these are rough estimates. Amazon never disclosed the specific financial impact of one-click as a separate line item. What we do know is that the patent helped Amazon during a critical period. The late 1990s and early 2000s were when e-commerce was establishing itself. Companies were figuring out how to sell online effectively. Customer habits were being formed. Having the fastest, easiest checkout during that formative period gave Amazon an edge. Customers got used to the convenience of buying on Amazon. Once you're trained to expect one-click purchasing, going to a competitor's website that makes you fill out forms feels annoying. You just go back to Amazon. The patent finally expired on September 12, 2017, exactly 20 years after it was filed. At that point, any company could legally implement one-click purchasing without paying Amazon or risking a lawsuit. But something interesting happened. Most companies didn't rush to add the feature. Some did, but many retailers stuck with their existing checkout processes. Why? Because by 2017, the technology had evolved. Mobile payment systems like Apple Pay, Google Pay, and PayPal One Touch had become popular. These systems let you buy things with one tap using biometric authentication like fingerprint or face recognition. They're actually faster and more secure than Amazon's original. One click. The technology that Amazon had monopolized for 20 years was becoming less relevant by the time the monopoly ended. There's a bigger lesson here about patents and technology. Patents last 20 years, but technology evolves much faster than that. A patent that covers cutting-edge technology today might be protecting something obsolete in 10 years. Amazon's one-click was revolutionary in 1997 when everyone was using slow dial-up internet and desktop computers. By 2017, everyone was using smartphones with fast mobile internet and integrated payment systems. The patent held back competition in its specific technical approach, but it couldn't stop the development of better technologies that worked differently. After the controversy around Amazon's patent and similar cases, There was growing pressure to reform how the Patent Office handled software and business method patents. The criticism was that too many obvious ideas were getting patented, and it was hurting innovation instead of encouraging it. In 2014, the Supreme Court issued a ruling in a case called Alice Corporation versus CLS Bank International. That ruling made it much harder to patent software and business methods. The court said you can't just take an abstract idea and patent it by saying you're doing it on a computer. You need to add something inventive beyond the basic concept. The ruling didn't invalidate existing patents like Amazon's one-click, but it changed how the Patent Office evaluates new applications. If Amazon had tried to file the same patent after 2014, it probably would have been rejected as too obvious. But by 2014, the patent only had 3 years left anyway. Amazon had already gotten almost the full 20-year benefit. So did the patent make Jeff Bezos a billionaire? Not by itself. Bezos became a billionaire because Amazon successfully grew from an online bookstore into a massive e-commerce platform, then expanded into cloud computing, digital media, hardware, logistics, and other industries. The one-click patent contributed to that success, but it was one piece among many. Amazon's logistics network, its recommendation algorithms, its marketplace platform, Amazon Web Services, all of these were probably more important to Amazon's dominance than the one-click patent. But the patent did matter. It gave Amazon a competitive advantage during a crucial period. It generated revenue through licensing deals. It forced competitors to use inferior checkout processes. And it established Amazon's reputation as a company that would aggressively defend its intellectual property. All of that helped Amazon grow faster than it might have otherwise. The story of the one-click patent is really a story about patents themselves. What should be patentable? How do we balance rewarding innovation against preventing monopolies? Should software be treated differently than physical inventions? These questions don't have easy answers, and different people have strong opinions based on their values and interests. If you're a big company with lots of patents, you probably support strong patent protections. Patents let you protect your investments in research and development. They give you leverage in negotiations with other companies. They create barriers to entry that keep new competitors from disrupting your business. From this perspective, the patent system is working as intended. It rewards companies that innovate by giving them temporary monopolies. If you're a small startup or an independent developer, you probably think the patent system is broken. You see patents being used by big companies to crush competition and extract licensing fees. You see obvious ideas being patented just because someone filed paperwork first. You see the cost of patent litigation making it impossible for small players to compete. From this perspective, patents have become weapons that hurt innovation instead of encouraging it. Both perspectives have some truth to them. Patents do encourage some innovation by protecting investments, but they also create monopolies that can block competition. The question is whether the benefits outweigh the costs. For software and business methods, a lot of experts think the costs are higher than the benefits. Technology moves too fast for 20-year patents to make sense. But changing the system requires political will, and big companies with lots of patents lobby hard to keep things as they are. The one-click patent controversy helped shift public opinion and eventually led to reforms like the Alice ruling. But those reforms came too late to affect Amazon's patent. Bezos got his 20-year monopoly, used it to strengthen Amazon's market position, and collected licensing fees along the way. By the time the rules changed, Amazon was too dominant for it to matter. Whether you think that's fair or not depends on your perspective. Bezos followed the rules as they existed. He didn't break any laws. He filed a patent application, it was approved, and he enforced his rights under that patent. That's how the system is designed to work. If you think the outcome was wrong, the problem is with the system, not with Bezos for using it. On the other hand, just because something is legal doesn't mean it's right. The patent system is supposed to encourage innovation, not block it. If granting the one-click patent ended up hurting innovation by preventing competitors from implementing obvious improvements, then the system failed in this case. Bezos might have followed the rules, but maybe the rules themselves were wrong. There's no objective answer to this. It's a matter of values and priorities. Do you prioritize protecting the rights of whoever files a patent first, or do you prioritize keeping obvious ideas available for everyone to use? Do you think temporary monopolies are worth the cost of reduced competition? These are political and philosophical questions, not technical ones. What we can say for certain is that the one-click patent was valuable to Amazon, controversial in the tech industry, and influential in the broader debate about software patents. It's a case study in how intellectual property law shapes competition and innovation in the technology sector. And it's a reminder that sometimes the most valuable innovations aren't the most technically complex. Sometimes the most valuable thing is just figuring out how to remove one small piece of friction from a process that millions of people use every day. Amazon's one-click patent, US 59604 Butwainche, was filed in 1997, granted in 1999, defended aggressively through lawsuits and licensing deals, and expired in 2017. It covered a specific technical implementation of single-action purchasing that gave Amazon a competitive advantage in e-commerce for 2 decades. Whether that was brilliant business strategy or exploitation of a flawed patent system depends on who you ask. But either way, it's now part of the history of how the internet became commercial and how one company used the legal system to help build an empire. Subscribe if you want more stories about how technology and business really work.